When the Supreme Court ruled in Marbury versus Madison, way back in 1803, it did more than just resolve a political quarrel between outgoing Federalists and an incoming administration. It actually claimed for itself the power to decide whether acts of Congress were constitutional. That moment, later celebrated as the birth of what we call judicial review, didn't merely recognize an existing authority, it created one. And in creating it, the court quietly shifted the balance of the entire constitutional system. The logic looked simple enough. The Constitution is the supreme law, judges must follow the law, so therefore judges must disregard unconstitutional statutes. But beneath that tidy syllogism lay an institutional transformation. The court presented itself as the final interpreter of the Constitution, a role nowhere granted in the text, never approved by amendment, and never really consented to by the people. Over time, that assumption hardened into doctrine, and doctrine into habit. The judiciary became the ultimate supervisor of the political branches, not because the Constitution required it, but simply because no one stopped it. The result wasn't a single seizure of power, but a chain of mutually reinforcing shifts. Each subtle change encouraged the next, until judicial supremacy became both familiar and unquestioned. What follows is a map of those reinforcing relationships. The court's earliest claims to invalidate statutes relieved Congress and state legislatures of a burden the Constitution had originally placed on them: the burden of constitutional self-restraint. Once legislators knew that judges would fix or strike down unconstitutional measures, they no longer felt compelled to scrutinize their own work. They drafted vague, contradictory, or open-ended statutes and trusted the judiciary to straighten them out. That habit pulled the court into the role of policymaker. Every time a judge filled a gap, reconciled a contradiction, or supplied missing structure, judicial review expanded from a defensive tool to a constructive one. Over decades, the court's continual repair work transformed its position from guardian of limits to co-author of law. Judicial review did not remain a break. It became part of the steering mechanism. Once the court's interpretations were treated as binding on the other branches, a second shift emerged. Presidents and legislators gradually abandoned their own responsibility to interpret the Constitution. They came to regard the court as the sole constitutional authority. That posture reshaped public expectations. Citizens learned to assume that constitutional meaning belonged to the court, not to elected officials and not to themselves. The more officials deferred, the more the public believed the court must be the proper final arbiter, and the more the public believed that, the more deference seemed appropriate. Judicial supremacy fed public confidence, and public confidence fed judicial supremacy. A loop of authority formed and reinforced itself. The Constitution nowhere grants the court the authority to nullify legislation. Early justices filled that silence with structural inference. Because the Constitution is supreme, judges must disregard unconstitutional laws. But an inference is not a mandate. It becomes a mandate only after it is used. Once the court invoked that reasoning in Marbury, its own decisions became sources of legitimacy. Precedent accumulated. The longer the practice continued, the more natural it looked. A doctrine born from silence acquired the appearance of command. What started as an interpretive convenience solidified into constitutional orthodoxy. Continuity replaced consent as the basis for authority. Article 3 gave the federal judiciary jurisdiction primarily over controversies between parties, especially conflicts between states or between states and citizens of other states. It did not create a roving power to arbitrate conflicts among laws themselves. But once the court became the forum for interstate disputes, it found itself at the nexus of federal relationships. From that vantage point, it began to treat clashes between laws, federal versus state, statute versus constitution, as disputes in their own right. That expansion transformed the court from an umpire settling concrete conflicts into an architect shaping the constitutional landscape. It no longer merely resolved cases. It defined the structural order within which all cases arose. As judicial review became the preferred safeguard of constitutional limits, responsibility evaporated from the political branches. Congress no longer felt compelled to weigh the constitutionality of its own acts. It passed controversial or speculative legislation, expecting the court to assess the boundaries later. Two habits entwined, relying on the court and avoiding accountability. The more lawmakers deferred, the more indispensable the court became. The more indispensable it became, the more lawmakers deferred. The center of constitutional responsibility migrated away from elected representatives and lodged in an unelected judiciary. The branch least accountable became the branch most influential. The Constitution's original design envisioned a judiciary limited to concrete disputes, a branch neither dominant nor politically directive. But that design faded as political leaders and citizens accepted the court's expanded role. The new arrangement, once it settled into place, appeared orderly and stable. Because it functioned smoothly, it seemed legitimate. In that apparent harmony lay the deeper shift. Stability concealed transformation. With each passing generation, the original balance was less remembered, and the new order felt more natural. What began as a deviation became the norm, sustained not by argument, but by forgetfulness. As judicial supremacy became entrenched, legislative precision deteriorated further. Lawmakers grew increasingly confident that the court would intervene whenever necessary. That sloppiness forced the court into even deeper policy-making. The more involved the judiciary became, the more irrevocable its supremacy appeared. Thus, the initial overreach of Marbury matured into a self-perpetuating system. Judicial supremacy, born in a moment of opportunism, embedded itself through the routine operations of government. The transfer of final constitutional authority from elected branches to the judiciary, once subtle, became nearly impossible to reverse. A quiet revolution became an accepted framework of governance. No amendment ever granted the court the final say on constitutional meaning. No referendum endorsed it. No constitutional convention debated it. Yet the institution now reigns as if such authorization had been given. Its defenders rely on continuity as evidence of legitimacy. Because the system has endured, it must be correct. But duration is not consent. A power not granted by the people does not become rightful merely by being exercised long enough. Endurance can mask the absence of authority. Judicial supremacy persists because each generation inherits it, not because any generation ever chose it. If Marbury versus Madison quietly consolidated constitutional meaning in a single federal tribunal, then restoring balance begins where that meaning originally resided, in the states. The Constitution did not summon the states into existence. The states existed first, and by their sovereign consent, they created the federal government. That consent formed the Union, and their continuing consent sustains it. The issue, therefore, is not whether the United States Supreme Court stands at the top of the federal judiciary. It does. That is its proper jurisdictional role. The real question is different. Must state courts, creatures of their own constitutions and responsible to their own citizens, Treat federal judicial opinions as binding commands of thought. Nothing in the Constitution requires this. The Supremacy Clause elevates the Constitution itself and laws made in pursuance thereof, not judicial interpretations, not precedents, not opinions of federal judges. When a state Supreme Court interprets the federal Constitution, it is engaging the same text to which federal judges appeal. The claim that state courts are bound by United States Supreme Court precedent is not a constitutional mandate. It is a convention of professional deference. And conventions, unlike constitutions, can be reconsidered. A single state Supreme Court could begin this reconsideration without defiance, without confrontation, and without rejecting federal authority. In a case presenting a federal question, it could simply state, "We respect the reasoning of the United States Supreme Court, but we are not constitutionally bound by its interpretations. Our duty, under our oath, is to interpret the Constitution itself, not to adopt the views of another court." This alone would reopen a constitutional dialogue that has been dormant since Marbury. It would not be nullification. It would not be secession. It would be fidelity. Fidelity to the Constitution directly, rather than to a judicial monopoly over its meaning. State judges swear the same oath as federal judges to the same document. Honoring that oath requires interpretation, not submission. If even a few states followed this path, the question would return, inevitably, to the national stage. Is the price of uniformity the surrender of interpretive independence? This is precisely the question the founders left to the people, not to the courts. The Constitution nowhere resolves it. That silence means the resolution must come from political judgment, not from judicial decree. If the states assert their interpretive authority and the national government accepts this pluralism by inaction, that very silence becomes an act of assent. A peaceful, incremental rebalancing of constitutional power toward the distributed sovereignty built into federalism. If, on the other hand, Congress or the states call a constitutional convention, then the people will supply what has always been missing: explicit consent regarding the scope of judicial supremacy. Either outcome would be constitutional, either outcome would be democratic. What neither outcome would be is judicially dictated. The Supreme Court cannot unmake the sovereign people who made the Constitution. The states, through their own courts, remain the living witnesses of that sovereignty. Their obedience to Marbury has been customary, not compulsory. Choosing a different course would not fracture the Union. It would remind the Union of the principles that formed it. A rebalancing of constitutional authority does not require rebellion. It requires memory. Memory of the simple truth that consent, not precedent, is the highest law in a republic. So the next step is not abstract. It's not theoretical. It's local, lawful, and immediate. Every one of us lives under a state constitution, in a state whose Supreme Court exists independently of the federal judiciary. Those justices swore the same oath as their federal counterparts, not to follow Supreme Court precedent, but to uphold the Constitution of the United States. And they retain the lawful authority to do so on their own terms. If we want to restore the balance that Marbury displaced, it begins with a single state court deciding to interpret the Constitution for itself. No defiance is needed, just fidelity. No confrontation, just courage. To help take that step, we've prepared a form letter to help demand your state Supreme Court acknowledge their rightful authority to interpret the Constitution directly, and to say so in a future opinion when the opportunity arises. This is not protest, it is persuasion. This is not radical, it is Republican, and it's time. Send a letter. When even one court remembers its duty, others will follow. That's how precedent is formed too.